Do you know what the 5 biggest mistakes people make when creating powers of attorney in Ohio are? You're about to find out right now. Hey guys, Elliott Feldman here, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. If you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. Okay, let's talk about the 5 biggest mistakes people make when creating powers of attorney in Ohio. So, as you know, a power of attorney is the legal document that you use in your estate plan to name a person you want to have the authority to make financial and healthcare decisions on your behalf when you are unable to do so. But there are common mistakes people make when creating powers of attorney that you need to be aware of before signing these powers away. Number 1, picking the wrong person to be your power of attorney. Look, when you make someone your power of attorney, it's like a double-edged sword because you're typically giving this person virtually unlimited capabilities to make financial decisions on your behalf when you're unable to do so, which is great if you become mentally incapacitated by, being in a freak accident or in a coma or fall victim to dementia. It's great to know someone will be able to, immediately have access and authority to your bank accounts and pay your bills on your behalf when you're out of it. However, the other edge of the sword comes into play if you choose the wrong person to be your power of attorney, because this person will immediately be given the authority to access your financial accounts, which means that they could theoretically walk into your bank and drain you of all your funds, right? Now, don't worry, just because they have the ability to do this does not mean that they should, and quite frankly, a power of attorney owes you legal duties of loyalty and to act in your best interest. So if they just waltzed into your bank to clean you out to take the money and run, that's theft and that's illegal. But still, you'd have to track them down like Liam Neeson and Taken and ultimately have to sue them to get the money back. And that's a process in and of itself, and I'm sure you'd like to avoid it. So it's best to just pick a close friend or family member that you know is truly trustworthy, truly responsible, to name them as your power of attorney. Number 2, creating a springing power of attorney. A springing power of attorney is where you prevent your agent from being able to act on your behalf until it has been determined that you've become mentally incapacitated. Okay, so assuming you have picked the right person to be your power of attorney who you know to be responsible and you know you can trust, the biggest mistake you can make is to give that person a springing power of attorney rather than an immediate power of attorney where they can immediately act on your behalf. You see, the big issue with springing powers of attorney is defining the criteria to determine if you become mentally incapacitated. You see, mental incapacity is sometimes tricky to define, and it can be tough to get doctors together to sign affidavits stating that you're incapacitated based on the criteria you've defined in your document. As you can imagine, by adding this hoop to jump through, this can seriously delay the agent you named to be your springing durable power of attorney from actually getting the power to act on your behalf at a time when decisions typically need to be made fast. Number 3, not having the right language in your power of attorney document to convey certain types of authority. Okay, this comes up a lot when you're creating a durable healthcare power of attorney where you're naming someone to make medical decisions on your behalf when you're mentally incapacitated. You see, in Ohio, the state law requires certain statements and notices are to be written into the healthcare power of attorney document in order for it to be valid and give that person that you name to be your healthcare power of attorney the power to act on your behalf. Yes, meaning if it's not written the correct way, it's not valid, and that person can't make any decisions on your behalf. Or as another example, if you want to make sure that your power of attorney can make gifts to family and friends on your behalf, then you need to explicitly state that in your document in order to make sure that any gifts your power of attorney gives will actually be treated as gifts for gift tax purposes by the IRS. So by not actually stating the right language in the document itself, you're asking for trouble in many circumstances. Number 4, failing to make sure your banks and hospitals will honor your power of attorney. Okay, so just because you've created a power of attorney, that doesn't mean that third parties will be forced to honor your power of attorney. When this example comes up in a hospital scenario, it's usually because your healthcare power of attorney was not created using the standard Ohio form document. You see, if you created a customized healthcare power of attorney document and not the standard form document, then it likely will not be recognized by the hospital when it's presented to them. which could cause delays in getting the decisions made on your behalf, by your healthcare power of attorney. But if you use the standard Ohio form, which is created out of the Ohio state law itself, then it likely will be readily recognized by the hospital and they will follow the wishes of your healthcare power of attorney. However, when it comes to getting your bank to accept your power of attorney document, it's a little trickier. You see, from the bank's perspective, if the power of attorney was found to be invalid and your agent just came in and took all the money out of your savings account, then the bank could be liable for failing to protect your interests. So even if your power of attorney document complies with Ohio law, it may not comply with the bank's internal policy, and thus the bank refuses to follow it and refuses to allow your agent to gain access to your accounts. That's why I always tell clients that as soon as you get your estate plan finalized, call a representative at your bank to let them know that you've just executed power of attorney and ask them ultimately what they need from you to ensure that they approve and accept your power of attorney should it ever need to be executed by your agent. Number 5, forgetting to record your power of attorney at your county's recorder's office when trying to transact in real estate. Okay, so you're about to close on the selling of a house located in Franklin County, but you're going to be out of town for a month during the time when the closing date is scheduled. So in order to solve this problem, you want to give a limited power of attorney to your brother so he can go to the closing table on your behalf and sign the deed for you to make sure your house gets sold. But if you left town before recording this power of attorney document at the Franklin County's recorder's office, then your brother would not be able to sign on your behalf. You see, in Ohio, if you want to give the person you name as power of attorney the ability to buy, sell, or lease your real estate, then you'll need to record that power of attorney document at the county's recorder's office in the county where the property is located. So that's also something very important to keep in mind. All right, there are 5 mistakes that people make when creating powers of attorney in Ohio. Number 1 is picking the wrong person to be your power of attorney. Number 2 is creating a springing power of attorney. Number 3 is not having the right language in your power of attorney document to convey certain types of authority. Number 4 is failing to make sure your banks and hospitals will honor your power of attorney. And finally, number 5, forgetting to record your power of attorney at your county's recorder's office when trying to transact in real estate. Hey, thanks so much for taking the time to watch this video. Don't forget to hit that subscribe button and the notifications bell next to it to be notified for new videos I post each week. And if you like it, then please hit the like button. And if you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave it. And if you ever have any questions about this topic or need to talk about your estate planning needs, you can set up a time to talk with me over the phone for free by going to myestatemeeting.com. That's myestatemeeting.com. Again, this is Elliott Feldman, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. Take care.